Noel is a practising barrister who specialises in criminal law, human rights and animal law. He's lectured and written widely on all those subjects, and his presentation will summarise the reasons the 2004 Hunting Act was introduced and will examine in depth the effects of a possible governmental repeal of that Act. I should also say that Noel has recently joined us at the Centre for Animal Welfare as a visiting professor. We're very excited to have him come, being one of the leading animal law barristers in the country. And he is helping us to prepare, in fact he is very much preparing the animal law content that we'll be delivering in our future master's course. So excited to have Noel on board. So thank you very much indeed, Noel. I'll just load up a background slide and leave it to you to take it away.
Dog fighting is so manifestly a cruel pastime. It has been a crime since 1835. Nevertheless, dog fighting is on the increase in this country, especially in the Midlands, where it's been imported from abroad. And so the bloodlust and blood money continues in the blood sport for criminals. Dog fighting for them is no different than badger baiting or fox hunting. And there is a connection with dog fighting and the Hunting Act 2004 in this respect. The Animal Welfare Act 2006, one of the most far-reaching animal welfare legislation introduced anywhere in the world, repealed for the main part the Protection of Animals Act 1911 and made radical changes which, if the Hunting Act 2004 is repealed, may have startling results. Briefly, I refer to the Burns report in 2000, where they did an extensive examination and analysis of hunting. But what was particularly important about it was this. Though they heard from over 400 witnesses across the board, they were not concerned with the theoretical aspects of fox hunting, but the pure practice. So to that extent, they did, for instance, carried out a post-mortem of a fox at the University of Bristol. And there they found injuries to the neck, the head, the face, and the eye of the fox. And that was one of the reasons that led them to think, much as was indicated on the last slide, seriously compromises the welfare of the fox. Well, I suppose if you've had a mass of uncontrolled hounds nipping at you, biting you, killing you, that just might compromise your welfare, as you're now dead. For our purpose, however, the importance of it is this too. In terms of the digging out, in terms of the terrier men, in terms of the general chase, you have a protracted time and you have an animal that cannot escape. But that's what I want you to lock into. We then move on because there was parliamentary debate from 1997 to 2004, which resulted in the Hunting Act 2004. And then we had the Countryside Alliance case before the House of Lords in 2007. And in that case, all five the most senior judges in the English judiciary rejected every single application the Countryside Alliance put forward. And what Lord Bingham in particular, one of the really great English judges, said about it, the 2004 Act, they were claiming that it was unlawful, against their human rights, it was incompatible with the convention and so on. He said, no, it's been introduced as a moral imperative. Effectively, it was ethical because people could not accept the fact of suffering being caused to animals in the name of sport. And at one stage, he examined as to whether animals actually suffered during the hunt, because the position of the applicant was no, what suffering to animals in a hunt? How could that possibly be? And he just completely demolished it, saying it's a matter of common sense. To think otherwise stretches, this is his exact words, to think otherwise stretches credulity beyond straining point. Now thereafter, we look to the Act itself, and I won't go into complex legal points, but it is important that you keep these in mind, because what I'm going to ask you to consider is the interaction of sections within the 2006 Act, which will then lead to a conclusion that I suggest is inescapable. And first, we look to Section 2 of the 2006 Act, and this is the definition of a protected animal. And a protected animal is an animal for the purposes of this Act if it is of a kind which is commonly domesticated in the British Islands. That's the first thing, commonly domesticated. Or it is under the control of man, whether on a permanent or temporary basis. That's the second. Or it is not living in a wild state. Now the importance of that is this. If it is a protected animal, then it's within the Act anyway and has all the legal rights that the Act itself puts forward. Don't, however, imagine that if it is not a protected animal, it has no legal rights and no protection at all. That's merely the highest. And as a result, even an animal that might otherwise, say, be in a wild state, a pet rat, if it is then taken on board by someone and adopted as a pet, it is then a protected animal. Equally, and this is the essence of its application to hunting, if it is in a temporary or permanent place that is under the control of man, then it's also a protected animal. And you have seen the slides there in terms of how it could be that a fox is in effect controlled by tracking and tracing and trapping. If someone cannot escape, then how can it be other than control? It doesn't have to be possession, it doesn't have to be custody, and it doesn't have to be knowledge. It has to be control. Now it goes further, for that matter. We then turn to Section 3, and you will see how these not only unfold, but how, as the various sections themselves interlock, it gives more protection to animals than at first it might appear. Section 3 says this, heading Responsibility for Animals. In this Act, references to a person responsible for an animal are to a person responsible for an animal, whether on a permanent or temporary basis. 2. In this Act, references to being responsible for an animal include being in charge of it. The importance of that is this. If someone other than the owner accepts responsibility for an animal, he's thereafter got a legal duty in relation to and in respect of that animal. The owner, however, doesn't escape either, because it is a joint liability. So it's an additional factor, even if the animal was not initially protected. It would apply to a vet having care of an animal overnight. It would apply to somebody in a sanctuary. Indeed, it would apply to someone even if it was illegal to have the animal. A pit bull terrier seized by the police. The police would then have a legal duty towards that animal, even if the owner was in prison. And so we have Section 2, protected animal. We have Section 3, responsibility for an animal. We then come to perhaps the core, the heart of the Act, Section 4. And this was really the culmination of the Burns report and the Countryside case. And you can see it at 1 because it's important to understand this. Under the old Act, everything was concerned with cruelty. Though the 2006 Act has 69 sections and 4 schedules, cruelty is a concept definition, and that is deliberate, because this has revolutionized animal welfare. All of the old acts, all of the old jurisprudence, all of the old cases are truly moribund. You cannot rely upon them in court, and there's a decision on that. And so we turn to Section 4, and the heading is unnecessary suffering. And it's a person commits an offence if an act of his or a failure of his causes an animal to suffer, and the animal is a protected animal. So again, you see already you're talking about unnecessary suffering and a protected animal. Then it gets even wider still. A person commits an offence if he's responsible for an animal. You recall the responsibility aspect in Section 3. And it causes the animal unnecessary suffering, another person. So you've then got the animal itself, if protected, has the rights within the Act. Then if somebody is responsible, they would be also liable for unnecessary suffering. The owner would be too. Now, this is where these things not merely dovetail, but impinge upon the fact of, if there is a change and the 2004 Act is repealed, it causes a problem for this government in this respect. And I would suggest they have overlooked the fact that when the 2004 Act was introduced, everything thereafter was affected by the 2006 Act. If you now repeal the 2004 Act, what's the position with regard to the Animal Welfare Act? And this is where the problem begins for the government. We now turn to Section 8, and that's concerned with fighting. Now, under the old Act, fighting was just a minimal factor as a form of cruelty. And that's just how it was mentioned, almost a minor aspect. And in terms of the interpretation, what is or is not cruel, and so on. Now, that is irrelevant, with no effect at all. Fighting, however, has almost 20 different forms. Anything you do, you breathe the same oxygen at an animal fight, you're guilty of a criminal offence. And this is what it says. A person commits an offence if he causes an animal fight to take place or attempts to do so. However, this is where the problem is inherent in any change. This is how it actually defines that crucial phrase. An animal fight means an occasion on which a protected animal is placed with an animal or with a human for the purpose of fighting, wrestling, or baiting. I trust you immediately see the point. What you've got is not a protected animal and a protected animal, but a protected animal and an animal. That's the point. So immediately you have a hound attacking a fox, an animal fight. Immediately you have a hound attacking a feral cat, it's a fight. Immediately you have a hound attacking a stray dog, it's an animal fight. And don't forget this, as to what I've just read out. It also involved human intervention. If the human was involved in the fight, that would also be an animal fight. And it's exceptionally wide, see it in that context. Now that has this problem for the government. Liz Truss has said that she will repeal it. When you examine it in that way, she is a modern Sisyphus. Because the point is this. If you have a situation where the 2004 Act is repealed, if the 2006 Act is still in existence, that would have to be repealed too. Because otherwise, when they involve themselves in fox hunting, they're involving themselves in an animal fight. And so if they then abolish the 2006 Act, fine. Dog fighting becomes legal. You also heard, and this is an interesting and significant point that flows from the situation, about how they had bred cubs nearby. If they breed the cubs, they've got this position and problem. If the cubs are adopted by them, they have a responsibility for it. It's then a protected animal. So if they set the hound on one of their cubs, they're involved in an animal fight. If they think this is problematic, we'll get rid of the cub, that's an abandonment, and that's a criminal offence under Section 9. And let me just finish on this note so that you can absorb and see the startling, stunning way in which this will evolve. In the most recent RSPCA bulletin of their annual review, a very interesting case in Durham where two men with 4 lurchers trapped a fox in a car park and set the lurchers upon it. And thereafter they goaded their dogs and made them effectively kill the fox. But during it, one of the men put his foot on the fox's neck and pushed the dogs away, then released it so the dogs would attack him again. And you hear them shouting and laughing and goading them on and saying, "Oh, see that, he had his eye out." And when I say that, this is first-hand. In the nature of criminals, they don't merely like to commit the crime, but to share it with other miscreants. So what they did was they put it on social media for their friends and malevolence and other curious, vicarious sadists. And so now the RSPCA did a very shrewd thing, because what they might have done with this, maybe charge them for Section 4 for unnecessary suffering, maybe animal welfare under Section 9 for responsibility. No, they charged them under Section 8 because they said it was an animal fight, and they were convicted. Now that's only another form, indistinguishable in truth, from fox hunting. But what you have now is this. While they may make the promises, it's really a question of Dave Cameron foxing the people and trying to fox the foxes too. Because whichever way you look at it, you have to, if you repeal the 2004 Act, and you then have to repeal the 2006 Act, and then dog fighting becomes legal. If you keep it in, then immediately they're involved in a fox hunt, they too will be committing a criminal act. And so what you'll have is the police will be using the dogs of law to hunt down the hunters. And so the hunters become their own quarry. Thank you.